So we are all living quite a bit longer. They've had their head in the sand all this time, and it comes as this big shock when mom falls and all of a sudden, needs care, or needs to relocate. So Shannon and I have made it our mission to educate, empower, and equip families and older adults so that when the crisis occurs, and that's when the crisis occurs, not if, because all of it, who's not getting older? Anybody? Okay, all right. So when the crisis occurs, that you'll be able to make knowledge-driven versus crisis-driven decisions. So that's our mission, and we're doing it one family at a time, and we know we can't get this message out to everyone, but we're trying our best. So these seminars, how many of you here have been to one of our seminars before? Oh, wow, we got a lot of repeat people today. Good. And you'll find, we call this an empowerment series because you're going to get a lot of our topics overlap each other. So to get the absolute most out of Seacoast seniors, keep coming back. And anyway, I appreciate you all coming today. So a little bit of housekeeping. The restrooms are out the door to the left, just a short ways down on the left, and you do need a key to get in. So we have some keys at the desk, so just borrow the key and bring it back so the next person can go. We do have 5 of them, so we can have 5 people going at once. Okay, so I think we have enough. On your clipboard, you have a little packet. On the front page is your notes. The second page talks about me and Shannon, of course, and since we promise never to give you a sales pitch, that's pretty much it for us tooting our own horn. And then loose from the packet, but on the last page of your clipboard, there's a feedback form. So how many of you got a learning card or brought one with you today? Everybody should have gotten a learning card. So your learning card gets a hole punched every time you turn in a feedback form. And you can only turn in one per seminar. But once you have 10, you get a $10 gift card to Panera Bread. So it's just kind of fun. And so that's what your learning cards are all about. We will have a question and answer session after we get done listening to our speakers. And so if you could jot down your questions and just hold them until we have that would be awesome. And I just want to thank my guests today for giving up their precious time. They're not getting paid for this. They value they share the same values that we do at Seacoast Seniors, and we're really feel honored that they decided to join us today. And I'd also like to give a big shout out to our sponsors. Our sponsors financially keep us going, and that's how we're able to offer these seminars to you completely free of charge. So thank you to our wonderful sponsors. All right, I'm going to let the guest speakers introduce themselves today just for the sake of time. So let's go ahead and get this party started. Did I forget anything, Michelle, or no? Didn't forget anything? Oh, I mentioned the bathroom cards. Yeah, okay. So I'm going to ask the speakers to introduce themselves, and we're going to start with Matthew. Tell us a little bit of who you are and what you do.
Sure, and thank you for having us, Nancy. I guess that check you wrote me earlier is no good. I'm disappointed to learn that. My name is Matthew O'Leary. I am a trust and estates attorney. I have been an attorney since 2010. I've been in trust and estates the entire time. I didn't just stumble into it because I thought it was available. A very intentional decision. It's a practice area that I love. Estate planning is a large portion of what we do. And the other half of what we do is administration or court-related things, but all connected to planning and taking back control when these life events happen. So everyone here is going to pass away. That's true every room that I've ever been in. And eventually that will happen, and that's a bad thing. But we can take back some of the uncertainty and create our own plan for how that's dealt with versus the default plan that's projected upon you if you don't. So I try to pitch people on the fact that we're taking control when we're doing our plan, and we're setting things up so that when a bad event happens, we've got the best possible outcome available. And I really like that practice here for that reason, because you can prophylactically address some of these things that we're all going to face. So my firm is called O'Leary Wallace, and we have we have an office in San Luis Obispo, and we have an office in North County.
Thank you, Matthew.
Hi, my name is Christina Gifford. I'm a CPA. I'm the accountant here at the table. I started practicing in the late 90s. 1997 was my very first tax season, so I've been preparing tax returns for a few years and am fairly well versed in various situations that may occur, including some of the situations that Matthew described earlier where there is planning and where there's not planning. And so hopefully today I can describe in a way that is meaningful, that you can understand, and not just use techie terminology and tax terminology, so that I can provide you some additional information and knowledge and some key takeaways after you leave here today.
Thank you, Christina.
Good morning. My name is Luke Andrini. I am the Undertaker. I wish it wasn't that obvious, but other than the fact that I look like Jeffrey Dahmer. But I was your local funeral director here in South County for 11 years. I trained under the great man Mike Lady for 7 years before I took over running the firm for 3 years. And then did some work in North County. I ran a firm up there. So I have experience both in private funeral homes and corporate funeral homes. There's a big difference we'll talk about. I've served thousands of families, and I'm proud to say I was one of the few who stayed open during the pandemic. I felt it was my duty to do so. So I have a lot of experience, and glad to be here today, and hopefully we'll learn something.
Wonderful. Thank you, Luke. Okay, so I lost my spot because I get so enthralled with what you guys are saying. Okay, well, let's go ahead and ask them some questions. Matthew, what is one of the things you wish people would do in advance of their passing?
That's a good question and a broad question, but everyone's life is their own, and so every situation is dependent on the facts that they're facing. But I wish that every person would, at the minimum, sit down, and even if they don't see a fancy lawyer, they just Google or go to the bookstore and get a statutory form power of attorney, so that they have someone who could jump in and help if they were in a situation where they couldn't help themselves. I wish they'd do the exact same thing for their health care, which you can often get at your doctor's office. But just those two basic acts will take away a big chunk of the uncertainty that folks run into when they're in a difficult situation, often later in life. But then more broadly, you have the opportunity to take things a step further. There is a plan, even if you don't have one written down. Everyone has an estate plan. It's just the plan that the default state of California, in its infinite wisdom, has put upon you if you don't write it. And so for some folks, that's kind of what they want, so it's fine. But for the vast majority of us, there's little changes or maybe big changes to that default plan. And it's scary to face it, and I think that's probably one of the main things I wish, is that it seems scary, and so folks have almost like a superstition about it sometimes. If I don't look at this, it'll never happen. And if you take the power back, if you take the control back and handle it that one time, one, you'll find you feel a lot better. Two, you'll find it's not that scary and you can deal with it later. And then three, your loved ones will always benefit in the long run. And that's why I like this practice area, because eventually I know that there'll be some value, some benefit that's conferred upon the family.
Thank you, Matthew. Christina, I'm sure that you have a few things that you wish clients would not do or do before while they're planning their estate. And for instance, what would be your response if I said to you, we've put the title of the house in our son or daughter's name so that when we die, it'll make things easier for them. How would you respond to that?
I would say, oh my gosh. So, from a tax perspective, specifically, just in regards to paying taxes, that is definitely not the recommended route to take. It might sound easier to do now so that your children or grandchildren don't have to manage it or deal with it later. Because at the time of your passing, they're probably already dealing with a lot. But from a tax perspective, that's probably one of the worst things that you can do, is to transfer that deed while you're still living. And it's slightly complicated, but to try to simplify it, just so that you understand a little bit of the background. How many of you have had or currently own your own home? So most of you, right? And out of all those people, how many of you have sold a home at one point or another? Most of you, right? And so in that situation, when you buy a home, I put cash down, and that's sort of what we call our basis, right? When I buy a house, I have some basis. And then over time, maybe you've made some improvements to the house. And so we take what you bought it for, plus what your improvements are, and now that's your new basis. Does that sort of make sense? And so if you bought that home 30 years ago, you probably have a fairly low basis, right? I mean, good for you, but you probably have a low basis. And if you transfer that deed while you're still living, your basis will transfer to your child or your grandchild or whoever you're going to deed the house to. So now they will have a very low basis. And when they go to sell it, they're going to sell it for a very high price, I hope, right? But the difference between the basis and what they sell it for is what your child is going to be taxed on potentially. And that could be a very large number. So if you bought that house 30 years ago and your basis is $200,000 and you're gonna pass away in 10 years and the fair market value of that house is now like 1.5 million, the difference between 200,000 and 1.5 million is significant, and they may have to pay tax on all of that. And so it's a significant tax burden, even though initially the transfer on the deed, you intended to make it easier and you intended to make it more efficient. What you are doing is potentially burdening this child or grandchild with some taxes that they had not expected.
Thank you, Christina. Luke, What do you do, or what do you wish people would arrange for either the survivors or the deceased, what they would do before their loved one passes away?
I'll start by tell you what most people do. There's a lot of emotion comes into this, especially on this end. If you're thinking if you're going to be leaving family members behind, especially children, this is a hard topic to bring up. In fact, I just went through this personally. My mother's in good health, but I had a question about what might happen after she passed away with an investment she had. And she answered, very cordially. It was a good conversation, but that little thought kind of got into her head, and she thought maybe I wanted to do away with her, right? And there was no, I like her enough, I want to keep her around. So it's hard to bring up, and so what a lot of people do, they just don't talk about it, for one. And I tell you what, I've sat down with enough children to know that they don't know what you were thinking in your head. They make assumptions, they might base it on if you're religious or not, but they never have a clue, and that causes the most anxiety in that room. And that's a very emotional time when you're visiting with someone like me. So what other people might do, if you haven't talked to your kids, maybe they write it down, they put it on a note, they might even sign it, but unfortunately it doesn't have as much legal basis as you might think. Things can get changed later by the next of kin, so your wishes may not even be carried out. We try and fight against this as much as we can, but the only real way to make sure your wishes are carried out is that you have a legal plan with the funeral home. And I do recommend at least trying to convey to your family what you want as best that you can. But you can set up your funeral plan with a specific funeral home ahead of time. It's no different than if you had actually passed away. The process is the same. Major difference being your emotional state is very different. It's pretty easy going. It can even be fun if you look at it the right way. But I mean, it's a big difference. And then when that day comes, that sigh of relief I get from the next of kin that it's all taken care of. Everything's in order, and the more meticulous, the better. And all they have to do is sign the documents and just hold on, through the journey. So that's what we're going to talk about more later. Is about the pre-planning process. I can't recommend it enough, and there's even some monetary reasons to do it. As far as savings, it is not cheap to die. And with inflation, it's getting worse by the day. I've never seen the prices go up faster. And then property is going through the roof, meaning cemetery property. If that's something that's important to you, this is the time to get on it. There's plenty of room, but it's just getting expensive, I care about your dollar. Other than that, for those maybe you don't have children, still worth doing. The only example I have was my landlord, my old landlord. He was a good guy, but he didn't have any kids, but he had a lot of stuff that meant something to him. And he didn't want it going to the feds after he passed. So this is another reason to just make sure things get tied up and make sure some third party doesn't care, won't just take it all away. So anyways, that's that.
Thank you, Luke. I didn't give you this, Matthew, on your list of questions, but I know it's an easy question for you. What do you say to people who say, it's all good, I've got a will, and I don't need a trust because they're expensive, and the attorneys are the only ones that benefit.
Say, let's not be so hard on those attorneys. I gotta switch to being the straight man because we have Luke here. I gotta stop. Nothing I say is gonna be funny compared to him. So that's honestly, I actually don't want to disappoint you with this answer, but I say that's fine. It's up to you. There are some very real benefits to having a trust, particularly if you own real estate. And so I will have clients say from time to time, well, once I pay off the house, then I'll come get my trust done. And that's not what I mean when I say own real estate. You own real estate even if you have a large mortgage. That's just an encumbrance. It's not the bank's house, it's your house. So I point out that if you have real estate and your estate is going to just pass according to a will, again, that's up to you. That's fine. But it will cost more and take much longer than it needed to. And so if you have just a regular old house that's $750,000 and maybe you had some other things and you have $250,000, but let's say maybe you had a $600,000 mortgage against that $750,000 house, your state will pay the attorneys $23,000, which again, let's not be hard on that, but they'll also pay the administrator $23,000. You'll pay $4,000 to $6,000 in court-related fees, and then you'll also be subject to some of the downsides of having a will, which is things like, what if one of your beneficiaries passed away? What if somebody in your life has special needs? What if you're providing for a child or a grandchild who's underage or who needs help with their financial management? And so you're limiting your options and your solutions by having just the will, and you're signing your state up to pay like $50,000 to $60,000 of fees that they probably didn't have to pay. And then meanwhile, you're signing your state up for a process that I used to say 9 months, 12 months, kind of at the outside end, but with ever since 2020, really, it's never kind of got back under control here in San Luis Obispo County. So if you file something today, you'll get a hearing date of November 5th. So you'll have months and months and months of these waiting periods. So it's like a 2-year process right now just to get that little will probated and your estate handled. So that's kind of a long answer, but those are kind of the general things I say. It's entirely up to the person, of course. If none of those things bother them, fine. But there are some alternatives that might be enticing.
And Matthew, one more question. How often do you recommend, if they do have a trust, that they update it?
Major life events is usually what I say. So that means birth, death, marriage, divorce, large change in financial net worth. If you just kind of want to have a marker in your head, you might take it out and try to recall what it says every 10 years or so. Because circumstances do change. The person who you thought was the best, most responsible person in your life, maybe that's not the same person anymore. But I really just say those major life events, birth, death, marriage, divorce, big change up or down in net worth.
Okay, so a lot of you have heard me say this before, but a lot of times when Shannon and I walk into someone's home to list their home, one of the first questions we ask is your property in a trust? The second question is, if they say yes, and they're always proud, oh yes, we have a trust. And, but so our second question is always, when is the last time you updated it? And then they're so cute. They look at each other and they say, well, I don't know, it's been about 20 or 30 years, and I think our attorney's dead. And then they look at me like, what do we do? And Matthew or any attorney can update your trust. You do not have to go back to the same attorney. If he's still working and local and you want to go through him, that's fine. But you can go to any attorney and have them review your trust and update it with changes that need to be made. So I always like to bring that up. Christina. Is giving money to my kids or grandkids considered a charitable donation that I can deduct?
Great question. The answer is no. Your children, as precious as they are not a charitable deduction. And we get that question a lot. There's a big difference between giving a gift to your kids or grandkids and giving a charitable donation. A charitable donation would be for any nonprofit that you like. I won't mention any particular ones right now as far as nonprofits because you're here in this seminar. But it could be anything. It could be the Red Cross. It could be any nonprofit organization you would give money to, and then maybe you would talk to your tax preparer about a deduction on your tax return for that. But when you give money or assets, any assets, it doesn't necessarily have to be $1, to your children or grandchildren, the federal government tells us each year how much you're allowed to give without any additional filings. And so we call that a gift tax return. And right now, we can say that you can give your children or grandchildren or stranger or your favorite lawyer or Undertaker, you can give them a gift of up to $18,000 without any additional filings. Now, sometimes people ask if you give your favorite Undertaker a gift of $18,000, do you have to pay tax on it because you're the one giving the gift? And the answer is no. And the other question I get is, if I give the Undertaker the $18,000, does the Undertaker have to pay tax on the gift I gave them? And the answer is no. But there are lifetime exclusions, and right now those lifetime exclusions are very, very high. They're in the $13 million category. And so most of us will never reach that lifetime exclusion, but you could ultimately give that $18,000 every year to however many people you want, until meeting that lifetime exclusion, and then at that point there are some tax implications involved. But those are some of the differences between giving to a charity and giving a gift to somebody you like or don't like.
Very direct. Thank you, Christina. So Luke, if the family doesn't agree with each other on whether mom should be cremated or have a burial, for instance, whose instructions would you follow?
Very good. Yeah, that's a problem. Unfortunately, it can be, it's pretty common, but there's simple, two answers. One, if you plan your funeral yourself, you're first in line to decide what you want to happen. So that's why, again, pre-planning is very important. But the other answer is next of kin. And we go down in order, and it goes spouse, children, siblings, and I never cared beyond that. Just whoever came, wanted to take that responsibility. Because no one wanted to do it beyond that. Maybe cousins, something like that. But yeah, keep in mind, your kids are next in line, so even if they don't want to take on that responsibility, they have to, which just adds a little more pressure if things are not already pre-planned. Yeah. So it doesn't mean other family members. We really want everyone to agree as much as possible. It's just obviously that's makes for a smoother process, but we will not take any directions from anyone other than, again, next of kin. Yeah.
Great, thanks, Luke. So you guys can talk as much as you want. We're going through these kind of quickly. Matthew, if I have a trust, do I need to put all of my assets in the trust?
Well, you don't have to, but I will say that if you have a trust, and this will happen from time to time, folks will have their fancy trust, and then they'll not put any assets into it, and they'll think, well, I'm fine. And they'll even say, sometimes if they're a little more sophisticated, they'll point out, well, when I did the trust, I did a will at the same time, and it says right here in the will that everything goes to my trust, so I must be okay. And the reality is that will, if you use it to fund your trust, if you use it to put all the assets into your trust that you want there, it actually still has to go through court. And so all the downsides of the court proceedings still will apply despite the fancy trust that you had done. So there are certain assets that are a no-brainer to fund into your trust. And the primary one is real estate. And that's because there is really limited options on making a smooth transition of real estate when you pass away without a trust. There are some, but they're just not quite as good. And so the first is real estate. After that, it's large investment accounts, large cash accounts. And when I say large, I say that for a reason, because the state of California will let $184,500, is that right? $184,500 pass outside of court, that's not in trust, and that does not have a beneficiary. They'll let the family, if you will, the heirs, whoever it is, they'll let them collect that amount of money without a court proceeding. So if you have just a few modest accounts, maybe you don't have to put those in trust. I still think it's a good idea, because when it's funded into your trust, when it's retitled to say the trust on it, that means that a successor trustee, the next person in line, can jump right in and help. They could take care of business. They could use it to pay the mortuary if that wasn't prearranged. They can do those really important things that happen that sometimes require a little urgency. And so they can do that if it's in trust. If it's not in trust, there's a little bit more of a waiting period, unless there are some other reasons. So there are some obvious things to put into trust. We always assign people's personal property into their trust. I do that so that there's no confusion about, wait a minute, mom said I could have this, but mom wrote in the trust something else. What about the jewelry? What about that? I do a document that says all of my stuff, my golf clubs, my lamps, my spoons, it's all part of my trust as soon as I sign this, and then I have a provision in the trust that says, maybe I'll write something down, maybe I won't, but this is where it's going to be discussed. It's not going to be some other outside thing. So I try to make everything consolidated in that place. I will tell you now, the one thing that will not go into your trust that folks sometimes are surprised by, but that's retirement accounts, tax qualified retirement accounts. Things like your Roth IRA, your 401k, your 403b, your whatever it might be. Those things are all going to be in the name of the employee, is what the regulations say. So they have to stay in your name, and they don't get changed into the trust, even if you have millions of dollars there. And so what we do instead is we try to work with your financial advisor, work with your CPA to make sure that we have the right designation for the beneficiary on those accounts. Maybe it's your spouse, but after that, I usually recommend it be the trust then at that point. And it would pass to your trust, and then depending who your heirs are, whether it goes directly to them in their own inherited account, or if it's managed by the trustee. Complication that doesn't matter for the purposes of this conversation, but the point is, we try to point it back to the trust at that point. People ask me about cars. Should cars be put into the trust? And generally, no. Actually, California, one thing we have kind of figured out, you can transfer cars pretty easily, and they won't require a probate, no matter how valuable they are. Jay Leno's car collection will actually pass outside of probate, presuming there's no probate. So you don't have to worry about cars. But in general, it's good to talk with a professional, or at least do your own research, because there's some certain things that are important and helpful if we title it into the trust. Is that too long of an answer?
No, that's good. And one of the situations, Shannon and I just had one, and there just seems to be a lot of confusion between power of attorneys and the successor trustee. So Shannon and I took a listing just a few months ago, And the son said, I've got a power of attorney. My dad's overwhelmed. Mom has dementia. They just moved into a senior community up north, and we have power of attorney, and so we're going to be handling everything. So we're like, okay, that's cool. So we sold it, and we'll go to open escrow, and I conveyed this information to the escrow officer, and she said, you can't have a power of attorney with a trust. And I said, oh. And so, even after 42 years in the business, I'm learning stuff every year. It's not always just the laws changing, it's just something I've never had to deal with before. And so, would you explain what the difference is between power of attorney and a successor trustee? Because people do seem to be confused about that.
Yeah, good question. And sometimes a trust will say that the trustee can actually have a power of attorney agent, if you will, and say, you can step into my shoes and be trustee for a bit or carry out these certain tasks. But that really is what a power of attorney is. It's taking a principal, the person who's writing the document, and it's naming an attorney in fact or an agent to say, step into my shoes and be me, the individual, in these certain circumstances. And if you got your document done by me, those circumstances would be vast. It would say anything and everything that I ever might encounter. You can step into my shoes, agent, and be my attorney, in fact, my power of attorney. And I would say in there, if it was my document, I would say, this applies if I'm incapacitated. This actually starts now, though, so you don't have to prove I'm incapacitated. Well, I trust you, therefore I want everyone else to trust you. And so you are now acting as that person. But it's a little confusing, but I think it will make sense if you think about it. Stepping into someone's shoes individually does not make you suddenly the thing that person goes and does. So if I was LeBron James' power of attorney, I wouldn't be on the Lakers, right? I would just get to do his banking, which would be awesome. But so if you're CEO of a company, your agent isn't suddenly CEO, because that's a different capacity that you were. That's not you as an individual. And so the conflict, if you will, or that dynamic between trustee and power of attorney, when I am serving as trustee, I'm in a capacity. It's like I'm CEO of this trust. I'm the manager. And so my personal capacity, that somebody's acting as my attorney in fact, doesn't suddenly give them the jobs I had. And so it doesn't make them trustee necessarily. But so why have a power of attorney if you have a trust, right? Some people will say that. Well, there's certain things, like the aforementioned tax qualified retirement account, that will be in your name, or your credit card will be in your name, or your mortgage will be in your name, even if you had your house in trust. They don't want you as trustee probably to sign for that mortgage. They want they want to get their teeth into you, the individual. So there are still certain things that will have your utility bill will come to you as an individual. So there's still certain jobs that you'll have, or certain things that'll be tied to you as the individual, and so you really want that power of attorney. But anything that's in trust is going to be managed by a successor trustee if it's not you, or if you're not the primary trustee when it gets created. So that interplay can happen, and I guess maybe it wasn't your situation, but a mortgage person called me this week with the same question, saying, wait a minute, we have power of attorney, but we see the house is in trust. What are we going to do? And the question is, the answer is, the trust should provide some plan, some solution to that, saying, if the trustee of the trust isn't able to take care of business, what's the process to get the next person in place to take care of business? And that's something that an attorney can help you with, or that's something that you might be able to just decipher by reading it. Not too bad, but it is two dueling capacities, if you will.
Yeah.
Just on the topic of power of attorney, it just reminded me, I forgot to mention, when it comes to next of kin, as far as stepping into someone's shoes like that, what supersedes even children in the list is power of attorney. We just have to make sure that it has a clause saying that this individual can make decisions for final arrangements. Some funeral directors will receive a durable power of attorney, but still reject it if it doesn't have that clause. We're just hyper careful with this because we can't undo the arrangements. So I wanted to, there are some situations where depending on the family dynamics, maybe you don't want your children making decisions. You want a third party to come in. That's where it's smart to appoint a friend, just someone that's trusted as power of attorney. Or in the case that there isn't much family or no one's willing to step up, if you're lucky enough to find someone to trust, help them through that process. And that's who I would take direction from, this power of attorney. I just wanted to add that.
I was actually going to mention that when Luke said it. So the look to, it's a healthcare power of attorney. It's the healthcare directive, and it could be in the power of attorney as well, but the law says the first person with priority is the advanced healthcare agent. And so go home and look if you have your will, because it's a very old common, but a little bit more old-fashioned technique. It will say maybe in your will, I would like to be buried, I would like to be cremated. It might say something like that. I always put that in the healthcare directive because people like Luke are going to look to that document first, and they may never look at the will. I mean, it's not in front of them, they're not the court, so they might not even know if you have one. But that healthcare directive, because that's first in line, that's where I like to put that in that direction if you haven't made that pre-plan like Luke was discussing.
Well, thank you, Matthew. And
What were you going to add
I'll
to
just a
that?
quick tag on that. It's, what did you say? Yeah, the healthcare directive. Crap.
did you lose it? Okay, well, if it comes back, just speak up. This is
Senior moment.
our seminars. That's what I tell people, seniors helping seniors. Luke doesn't qualify. So,
That's what it was. I had Matthew mentioned the will. Just this is my experience. We don't look at wills only if there's confusion about what to do. This is mostly the kids. They're tear up the house looking for the thing, only to find it maybe was vague on what they actually wanted. As far as final arrangements, or Matthew, I'm sure will clarify this. It might give who's the make directions, who's to actually make the arrangements. Sometimes that's on a will. We'll look for it, but I just wanted to say we usually do not look at the will, so just keep that in mind. I don't know if you want to add to that.
I would like to add something. If you are going to assign a power of attorney to someone, please get some legal advice. Don't download a power of attorney form and get somebody to record it for you. There are so many different types of power of attorney, and I know that's something Shannon and I have run into over the years, is people have a power of attorney and we'll ask them, well, to do what? And they don't know, and they don't even know where it is. We have one client, she never has produced that thing. Yeah, and so it's really important to get the advice that you need on something so important. Christina, if I do decide to sell my house, how can I avoid paying capital gains?
Well, I can help you reduce the capital gains, but I don't want to be quoted as avoiding capital gains. So I just want to be very clear. The first thing, nobody else stuck out this way.
I get it.
The first thing I would want to say, and this is meant to be humorous, but I would say the first thing I would recommend is stay married or get married. Because if you're trying to sell your primary residence, that's going to be the best assistance. I know I have a lot of confused faces out here, but let me explain why that's helpful. If you have a primary residence, meaning not a rental property, not a second home or an investment home, but a place that you receive mail and you live in and you consider your primary residence, and you have been there for a long period of time, and you haven't really recently sold any homes before within the last 2 out of the last 5 years, then when you do go to sell your home, the state of California and the IRS do provide some help with that. So we talked before about what basis is, and we talked before about selling. And the difference between your basis and what you can sell it for is typically how you, the homeowner of your primary residence, would get taxed. Now, the exclusions that are offered currently are $250,000 per person. So if you're married, you get a $500,000 exclusion. So my example was last time that we bought a house 30 years ago for $200,000, and we did $50,000 in improvements over the last 30 years. So our new basis is $250,000. And if I sell that, generally speaking, just simplifying the process, if I sell that home for $1 million, that's a big profit, right? Say $750,000 of profit. And typically that would be what you would pay your capital gains on. But now that this is your primary residence, and hopefully you either got married or are still married, you have $250,000 per person. So together you have a $500,000 exclusion. And so instead of paying tax on the $750,000, you get to pay tax on $250,000. And so it's this primary residence exclusion that we like to utilize. But the other thing to take into consideration is you've owned this home for 30 years. And you probably did quite a bit of improvements. And so keeping track of those improvements, as I have hopefully showed in my example, helps to increase your basis. My example to you was $50,000 of improvements, but lots of times there are kitchen remodels, and I added a deck, and I built a whatever, and I added to the garage, and those all add up. And you typically don't do them all at once. You do them over time because you saved money, or you got a line of credit, or whatever you needed to do over the period of time. And so keeping track of those improvements to help increase your basis is going to be very helpful when you go to actually sell your home. It will help to decrease the amount of capital gains, the amount of tax that you could potentially pay.
So Christina, how does it work if you are married and your spouse passes away? What happens to the capital gains amount then?
So although the amazing gentlemen on both sides of me, they deal with the sadder parts of passing. There is like a good glimmer of hope during a passing if you could find it in a tax situation. And we call that a step up in basis. And so in my example where you purchased your house 30 years ago with your spouse for $200,000, and if your spouse unfortunately does pass away today, and we've used in the example that I could sell that home for $1 million. Instead of the basis being $200,000 like we've been talking about, we take the fair market value of the date that your spouse died, and we say, this is your new basis. Now your basis is $1 million. And so that step up in basis when you're married, we are a community property state, so what's his is yours, and what's yours is his or hers or theirs or however. Everybody's stuff is community property. And so when a spouse passes away, we're using the example of real estate, but any asset you own gets a step up in basis, and that step up in basis can be very beneficial, especially when you've owned something for a very long time. And in our example, we bought that house 30 years ago for $200,000. We tried to sell it for $1 million. You know, we saw that there could be a taxable transaction there. But if I waited until my spouse died, and then I sold the house, my basis is now $1 million because I got the step up after he passed. And then I sold it for $1 million because maybe I sold it a week after he passed away. So 1 million minus 1 million is 0. So on a tax situation, that's really great news. Sorry that your spouse passed away.
Thank you, Christina. And one of the things either your estate attorney or your accountant is going to ask you if you did lose a spouse is what was the value of the property when they passed away? And a lot of times your spouse passed a couple, 2 or 3 years ago. And so they'll say, well, and the accountant wants to know what was your property worth in 2021, for instance. And so a lot of times the professionals will ask you to get an appraisal. Well, an appraisal is going to cost you about $650. Most attorneys and accountants will accept a broker, real estate broker opinion. And that is something, it's called a time of death market value that Shannon and I will do at any time for you. So we have all the numbers and we can determine the value at whatever date in the past you need to know about. And we type up the letter and we send it over to your accountant and you're good to go. It's also nice to just have in your file for when and if you decide to move down the road. So just call us, we're always happy to do it, and there's no cost. Okay, so what's your best advice, Matthew? Or have you already given it all? Or where do I start? Either one of those.
Vitamin D every day. That's probably number one. Best estate planning advice, I presume. You would look at your situation and picking a quality, dependable successor to help if anything happens, whether you're alive or not, is a really, really crucial decision. And when you make that decision, you don't base it just on one, who's necessarily the closest physically, and two, who you think is I hear this all the time, I'm naming my child, they live a state away, they're a CPA, or they're a CEO, or they're something that's high-powered and very busy. They're great with money, so I'll have them be my successor. And so that's not, you don't have to just pick the person who's closest. You definitely don't have to pick the person who's best with money that's in your life. But pick the person who's dependable, who's the type to get a job and will see it through all the way. And then you do really need to pick somebody who's not financially dependent upon you. So they don't have to be the best with money, but one of the biggest things that I see is folks naming somebody who's very close to them relationally, who's maybe very involved in their life, but who is in some way financially, let's just say, not totally independent. And that can become, that's probably where I see the most problems, because I don't think that anybody ever starts out thinking, I'm going to take advantage of my parent, or I'm going to start, take advantage of my siblings by getting something out of this. I think it happens as a slippery slope where they say, hey, we're in this together. Hey, I'm really advancing the cause for mom and dad by being here. I'm missing out on income opportunities by doing this. And it becomes this thing where it's no longer their money, it's kind of our money, and we're all kind of need it, and we're all kind of living on it. And that can be someone's family situation, and that's fine. But that's probably not the best choice for someone as a good successor. So that's the best advice I think I have, is to take a look at your situation and then try to pick a good successor who would jump in and help. That person who might not be your right financial person, that might be the perfect person for your healthcare decisions. To be that person who's the advocate, to be that person who's present and helpful, to be that person who is going to make tough decisions on your behalf, but in a really empathetic way. So those could be two totally different people. So take a review of your own life, I would say, and try to have talk to somebody if you haven't already about what plan might fit your life the best, and think about those successors.
Okay, and I just want to bring this up. Some of you have heard me talk about this before. If you don't have any family, or if you know that your family isn't emotionally or stable enough to handle the processing of a trust, and I can't tell you how many kids we talk down off from a ledge. Well, a couple of things on that. One of them is, if you are in a successor of an estate, you can go to an attorney and ask them to help you, guide you through, because there's a lot of responsibility as a successor trustee. But one of the options that you have if you don't have any family is to hire a fiduciary and hire someone that comes highly referred. Shannon and I have some fiduciaries we love. Your attorney will have the name of some fiduciaries, and then what they do, the way they get paid is they take a percentage of the estate when the estate has already been distributed, but they handle everything, and there's no cost up front. They get paid later. So I know that I have a fiduciary on my trust, and because I don't want my kids having to deal with all that. I've seen too many situations where the kids are just a basket case because they're trying to do everything that needs to be done to finish up their parents' affairs. So just something to think about. You got any final words for us, Christina?
From a tax perspective, I would say the best advice I could give you is don't ask for forgiveness. Please ask for permission first. When a transaction happens, I can't undo it. And seeking professional guidance before any major transactions happen, and that could be selling real estate, that could be really anything related to retirement accounts and how that might impact your tax return or the beneficiary's tax returns. It's difficult to undo certain things. So I would just say ask permission first. That would probably be my best guidance.
Wonderful. Luke, where do they start?
I'd start by thinking about a few things, because I've learned the less time you spend in a funeral home, the happier you are. So I'll just give you some things to think about so when you get in there, it's just more streamlined. Number one is, which funeral home do you choose? And I'm unbiased. I'm not, I left the funeral biz last year after over a decade. That accounts why I looked like a tweaked out Bill Hader, so it doesn't matter to me. So I'm not, but there's a difference. There's private, there's your local funeral home, and then you have corporate funeral homes. If you're planning on staying in the area for a while, or the rest of your life, I 100% recommend go to a family-owned funeral home. They're smaller, very efficient, oftentimes less expensive for the same service. That's how that's where I enjoyed my work. It's just me and my assistant. We ran the whole thing, and just the feeling you get. They're very caring people. Not that a corporate aren't, it's a bigger organization, there's more hands involved, just different. Now, but you might want to consider, now this would be like Dignity Memorial. They're a corporation nationwide. The reason you may consider them is if you don't feel that you'll be here permanently, that if you do move, it is much easier to move your plan to wherever you move, because there's going to be one within 50 miles of wherever you land. So that's step one. And then two, I always start with the question, cremation or burial? Cremation technically can be simpler, but not necessarily. You can still have a service if you want. We call it a memorial or a celebration of life. Burial, the biggest difference is cost, obviously. Burial means now you have to decide on cemetery property, which again, I recommend you buy it now. If you decide later you don't want to get buried, it's your property, you can sell it later at a profit, believe it or not. So it doesn't hurt to have it, right? And then there's a difference. There's district cemeteries. City cemeteries are less expensive. Corporate ones a little more. But that's, I would at least, if you can nail down if you want one or the other, it's a pretty big decision. I haven't even decided. It just depends on how I'm feeling about myself on that day, you know. But yeah, so if you decide that, the funeral director will walk you through all the little steps. It's really just picking out merchandise that goes with it, and yeah, get in there. And the last thing, the big reason monetarily to do this is you do not pay an extra dime to pre-plan your funeral. You pay exactly what it costs today, and it is guaranteed forever. And now let's say if you're worried about a local funeral home going out of business, they are legally required to transfer your, and you'll hear this word, pre-need. Pre-plan, we call it pre-need. So you might hear that word a lot. They got to transfer it to the funeral home that buys them. If for some reason that building does not become a funeral home, which is highly unlikely, you cannot convert funeral homes into anything else. Yeah. And that's good news, I'm telling you. So, and there's safety in that, right? So, yeah. So if you nail those things down, you're 90% of the way. Go meet your local funeral director. I promise you, they're the loveliest people. This business attracts the best, obviously. So, yeah, that's all I'll say on that.
Can I ask Luke a question?
Yes.
What, Luke, what do you think of, two things. What do you think of the Neptune Society? I know a lot of clients do their pre-planning there. And then what if I want some sort of military component, like if I want the color guard or if I want to be buried in a military cemetery?
Absolutely. To the military portion, I've done many military funerals. I think they're fantastic. Funeral director helps you through that process. The only thing they require is discharge forms. And I say that now because make sure they're on the top of the pile of all your, paperwork and stuff, because they always get lost and they are hard to find. If your family member was in the military after, I think, 1960 something, it's called a DD-214, okay? That's all they need. We set up the rest, and they're beautiful, very worth doing. To the other question, Neptune societies, this scumbags. I mean, no, they're all right. Yeah. But what they are, so there's cremation services. If you want the absolute least expensive cremation service, I have to say they are very efficient. But here's how they work. There is no Neptune Society. They don't have a door. They don't have an office. I believe there's one in Santa Barbara. That's it. They contract with a local crematory. It may not even be in your area. You rarely know ahead of time where it is because the contract changes from time to time. But if that does not matter to you, then actually it's a good option because you're going to get low cost. Gosh, I'm going to say this, it's not true. I beat their prices all the time. Go see your local funeral director. But if you already have a Neptune plan, rest assured, I've worked with them over many years. They're very efficient and it does go smoothly. I've never contracted with them. I know who has done it, but yeah, I don't want you to think that they're going to be, I already ruined that, but yeah.
Your jigs are great. Okay, we have a few minutes available for some questions from our guests. Are you
I have a
married?
question for the accountant. On the $500,000 exemption if you're married, what if you're not married, but you own the property with someone else? Do you each still get that 250 exemption if there's two names on the title?
Did
No.
everybody hear the question? Would you mind just repeating the question?
So the question was, if you're not married, but there's two or more people on title, how the exclusion that we talked about before works. And the exclusion is, if it's your primary residence and you're married, you both get 250.
Okay.
So if you're not married, then your tax return just has your name on it. And so you're part of the sale of that real estate.
Two parties live in the same.
Right,
residence.
but on your tax return,
Yes.
there's just one name.
Yes.
And so you just get the
Okay, but you still
250,000.
get it.
You get 250, right?
Okay.
So it's 250 each person, which is why it's 500 for married.
And also a question for the attorney. When you have a trust on your property and you sell that property and buy another property, does that trust, do you just amend that trust to the new property, or do you have to develop a new trust?
You probably don't have to change anything about the trust. You want to make sure you take title to your new property in the name of your trust. And then a lot of trusts will have a schedule of assets at the end of it. It's best practices to do that. They don't always, but they'll have a schedule of assets. And it's a good idea to update that schedule of assets in the back to say, oh wait, I don't own 123 Main Street anymore. I own 5676 6th Street, and just update it there. But the main thing to make sure you get done is just the new property that you're acquiring. Make sure you have title at close. They'll give you escrow instructions, and you can actually write this in, how you want to hold title. Or after it's done, do the transfer, but make sure you're holding title as trustee of your trust. It can absolutely be the same trust, probably should be the same trust that you already have.
If you don't buy another home, then does that trust just like go away?
Well, yeah, in a way, a trust is an agreement about property, but there's probably some property in your trust. So if you just sold your piece of real estate, never bought another one, the trust will still be there, and you should probably put the proceeds in an account that's in the name of your trust. It should be an investment account or savings account, whatever. But it should be titled in the name of your name as trustee of your trust. And so the trust doesn't just poof, vanish unless it's a very specific trust. Sometimes we'll do for vacation homes, intra-family situation, a very specific trust that's just for holding the property in Cayucas. And when the property in Cayucas sells, there's no more need for this trust. The proceeds are distributed at that time when the trust literally has no assets. It really ceases to be effective. But in general, just because you sold your home, you probably still have a trust, and you probably still want a trust, particularly if you have some proceeds from the sale.
Thank you.
Okay, so we have time for a couple more questions, and but all of the speakers have agreed to stay for a short while after the seminar. So if you have anything that's like of a personal nature, it's best to share with them one-on-one. Or if we didn't get time to hear your question, please feel free to approach them after we shut down. I see one person over there. Hello.
This is for the accountant. So you mentioned that we can give away a certain amount of money every year, as long as it's within a certain value, and there's no tax consequence for the giver or the receiver.
So his question is in regards to the gift. So right now the gift amount is $18,000, and all that means is that you can give me $18,000 and nobody else has to know about it except for your spouse, hopefully. But what that means is if you give me $19,000, that's more than the allowed amount. And when that happens, you, as the giver, will need to work with your tax preparer and file a gift tax return because you gave me more than the $18,000. And just because you're filing a gift tax return doesn't mean there's actually any tax associated with it. There may not be, there more than likely is not. but it still means that that's what that limit means. It means you could give me 18,000, your spouse can give me 18,000, everybody's happy. But if you give me more than that 18,000, then there's additional tax returns that have to be filed. But I don't pay tax on that money, and you don't pay tax on that money, assuming you haven't given a gift exceeding about $13 million, which I don't think you would have. But that gift is not just for one person. You could give me the 18, you can give Matthew the 18, and you can give Luke the 18, and you're still okay because you haven't given any one of us more than the 18. So you can give as many $18,000 gifts as you want, as long as they don't exceed. And again, just by exceeding it just means you have additional filings.
I understood that.
Okay.
What I wasn't clear on is, let's say I give you 18,000. So I don't have to pay tax on the 18,000 I give you. Does that mean I deduct it from my gross on my tax return?
No.
I just don't pay additional tax.
Right, you've already paid tax on that income.
Okay.
Yeah.
Thank you.
Is that 18,000, is that yearly?
It is, but it changes. It's directed by the IRS, so it's 18,000 right now. That doesn't mean it's gonna stay 18,000
So
18,000 per year.
per year,
per person.
per person.
Okay, we are going to have to close our question and answer so that we're true to our promise to get you out of here by 11:30. So it's not like I have anything against anybody. Can I have a big hand for all of our guests today? Look at them. You know, we talked earlier about people going and Googling and sometimes getting the bad guys. There's a lot of bad guys out there. We're here to tell you today that these are the good guys. These are the good guys, and our sponsors, those are people that we have vetted. Anyone that Shannon and I refer to you are vetted, and we know they're good, and we would refer them to our own family. So, okay, and we have a raffle coming up.